Break out the popcorn, guys. I have a crazy story to tell you this morning. I'll have more on that in just a moment. So imagine you could be in a situation where you're being evicted from your house trailer, and the deputies come to help you get your stuff out and go. You wind up getting into a tussle. You steal their deputy's patrol car, and the Court of Appeal says, you know what? We think you deserve a new trial. It's a funny story. So let's start where the Court of Appeals starts. Jason Michael Hurst, defendant, appeals his convictions for first-degree tampering and resisting arrest, claiming the circuit court erred in refusing to give justification by necessity instructions to the jury. Defendant correctly argues that he presented evidence at trial that, if believed, constituted substantial evidence that he was justified in defending himself and his wife against abuse by Newton County Sheriff's deputies. The judgment of the circuit court is reversed and the case is remanded for a new trial. So this is down in Newton County, which is down in Neosho, down in the southern part of Missouri. And I had a boss who once said that that is the part of Missouri where you do not need a radio to hear dueling banjos played. And of course, as sort of a side historical note, the dueling banjos actually was shot in Georgia on the Chattahoochee River. But at any rate, the metaphor is pretty apt. There are a lot of people there who live on the very edge of society, and I understand that sometimes when you don't have a lot of experience with the legal system, you think the only way to react is to react in a way that calls attention to where you're at. So let's look at basically what happened here and why the court ruled the way it did. Now, the court describes the arrest and events this way. Defendant was being evicted from a trailer home that he and wife resided in. As defendant was loading his belongings into the truck, officers from the Newton County Sheriff's Department arrived to remove defendant from the property for potential trespass. The officers asked defendant a couple of questions. A second or two after defendant gave his answer to the second question, the officers used their feet to sweep defendant's feet, and bam, defendant was on the ground. As he was falling, an officer maced him. One of the officers then placed a taser against his back, and another officer had another taser going to defendant's right side. Defendant testified, "At this moment, I am freaking out. I can see I'm buried. I'm laying in the gravel in my driveway, and I started freaking out and asking and yelling for help." Well, that certainly sounds like a little bit more violent arrest than was necessary, particularly since he hadn't actually had any contact with the deputies at that point. But it gets worse. Wife saw what was happening and yelled for officers to get off her husband. An officer replied to wife, "Don't worry, we're coming for you next." Wife ran across the street to her sister's house and resumed her observation from inside another car. Meanwhile, while defendant was on the ground with his arms and legs pinned, an officer sprayed mace directly down defendant's throat after he told officers that he already couldn't breathe. Defendant testified, "I felt like at this point they were trying to kill me, and I was literally on the verge of losing consciousness. The officers handcuffed defendant's wrists behind his back and literally tossed him into the back seat of the police cruiser. Defendant feigned unconsciousness, and his head was hanging outside one of the cruiser's doors. When defendant saw an officer starting to slam the door shut on his neck, defendant pulled his head back inside the car. The officers then opened both doors of the cruiser and began punching defendant in his ribs, kidneys, and back. Defendant testified that one of the officers then punched me right in my face, and it busted my head open above my left eyebrow, and I had blood pouring all down my face." Well, When a defendant is handcuffed, you can certainly encourage him to behave, but you can't assault him. You can't hit him. He is entitled to the protection of the law at that point. And this gentleman, if his story is to be believed, and I take no position as to whether or not his story should be believed, but if his story is to believe, he was treated pretty badly. Defendant then heard officers talk about taking him to the creek and going to get his wife. From the back of the patrol car, defendant saw officers cross the road and try to get wife out of the car she was sitting in. Wanting to distract the officers to keep wife safe, defendant managed to pull his handcuffs around to the front of his body, unlock the window between the front and back seats of the police car, and climb into the driver's seat. Still handcuffed, defendant started driving the patrol car toward town, where he thought security cameras would capture the incident. Defendant was also calling for help on the police radio. A chase ensued, and it finally ended when defendant's driver's side tires hit the curb, causing the vehicle to roll. So now we've got theft of a police car, damage to property, resisting arrest with violence. All of these charges are put on the defendant at court. So how does the Southern District of Missouri's Court of Appeals resolve this issue? Well, here's what the court said. Defendant's sole point on appeal claims the circuit court erred in refusing his submitted justification instructions in that viewed in the light most favorable to giving them, meaning the instructions, there was substantial evidence to support a finding that defendant was justified in defending himself and wife against abuse by officers. We agree. A defendant is entitled to an instruction if substantial evidence and the reasonable inferences drawn therefrom support the theory propounded in the requested instruction. And then the court cites a couple of cases. The court didn't stop there, though. It went on to say, our courts have construed substantial evidence to mean any theory of innocence, however improbable that theory may seem, so long as the most favorable construction of the evidence supports it. Now, the court relied a lot on the common law in this case, but it also relied on a statute in Missouri that codifies the common law defense of necessity. And here's what that statute says. The justification defense set forth in section 563.026 provides that conduct which would otherwise constitute any offense other than a Class A felony or murder is justifiable and not criminal when it is necessary as an emergency measure to avoid an imminent public or private injury which is about to occur by reason of a situation occasioned or developed through no fault of the actor, and which is of such gravity that according to ordinary standards of intelligence and morality, the desirability of avoiding the injury outweighs the desirability of avoiding an injury sought to be prevented by the statute defining the offense charge. Here's how the court resolved that. This is why they found that there was substantial evidence. Defendant testified that officers were hitting him with a taser, beating him bloody, and had sprayed mace down his throat when he was having difficulty breathing. Defendant believed the officers were going to kill him, and while on the brink of unconsciousness in the back of the police car, he had heard officers say to his wife, "Don't worry, you're next." Around that same time, defendant heard wife screaming for help. As you might guess, being familiar with the people in the Southern District and being familiar particularly with the people in the county where this all went down, the judge was having none of that. And the case recounts how he resolved the issue, basically saying he thought it was nonsense. But here's what the Southern District Court of Appeals said. The fatal flaws in the circuit court's reasoning for refusing the proffered instructions were in reducing the alleged misconduct by officers to kicking and relying upon evidence unfavorable to the submission of the requested instructions. The circuit court is required to view evidence in the light most favorable to the defendant and the theory propounded by the defendant. So the Southern District reversed the trial court's judgment and sent it back, remanded it for trial. Now that doesn't necessarily mean that that's what's going to happen, because as the Southern District notes, some of the cases that it cites were cases where one judge on the state Supreme Court dissented. And as a result of that, the Attorney General's office in Missouri may very well decide to go back and ask the Supreme Court to take transfer of that case. And that does happen from time to time. The Supreme Court will take a case that it believes has been decided wrong or that improperly or inaccurately describes the law of Missouri. So we may not have heard the last laugh on this case just yet, but at least as of the date of the opinion here, it looks to me like this gentleman is going to get a chance to have another shot at freedom. So if you've enjoyed this, you found it interesting or helpful in any way, I'd really appreciate a thumbs up, like, share, subscribe. You know, guys, all the things that all of us YouTubers ask you to do. We would really appreciate it if you would like and subscribe and share this video. Thank you so much for watching. If you have any questions about this, please feel free to leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel. Otherwise, I will catch you on here next time. Thank you so much for watching.